All right, welcome back. I've got a well, I've got a couple of good ones for you today. We'll see how far I get. I don't know. I'm not really feeling it today, but at the same time, I want to clear some of my backlog before I go on vacation at the end of the week. So, with that said, even if I'm not feeling it, I'm gonna do at least some, and we'll see how far I get. But first, as always, if you haven't already, or even if you have and you want to again, please go support Professor Scofield, her GoFundMe. I'll have it linked down at the bottom in the description. It's a good cause. It'll keep the lawsuit going so we can keep being entertained by it. And frankly, Professor Schofield is deserving. You know, she deserves to be able to properly clear her name from the defamation that Ashley Guillard has continued to do. So, that being said, we are headed back to Vegas, but not exactly Delete Lawz, although he features very prominently, like even more so than you'd expect. And so we're going to Floyd Wallace versus Las Vegas Metropolitan Police Department. It's been a little while since we have visited this one, but there was a flurry of filings. And so, just a reminder, Floyd Wallace is News Now Omaha, Passport Bro, News Now Future Statistic. And so yeah, we looked at the complaint. Wow, way back in May. Has it really been that long? Um, but yeah, so we looked at the complaint. It's almost identical to Delete Law's complaint, and there's good reason for that. It was probably written by Delete Lawz. I mean, it, or at least if it wasn't written by him, he handed Floyd his complaint and said, "Here, you can use this as a template," which, you know, I'm sure most of you are at least familiar with the YouTube channel, the DUI guy plus. You've got to remember the plus. Um, Larry Foreman, he I, I think it's Foreman, but Kentucky primarily does DUI defense, but he also does personal injury and um, general criminal defense, but his specialty is DUI defense. And so he's made quite a name for himself on YouTube. He was one of the channels covering the Johnny Depp Amber Heard, and he's still on that. Well, the other day he released a video. It was like 10 secrets of lawyers, 10 secrets that lawyers won't tell you, or something like that. And one of them was, if you are representing yourself, plagiarize, 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 which I agree with. It's, you're not in school. The teacher isn't going to slap your wrist and say, "Hey, you can't copy your neighbor." It's I've mentioned before, like in the Boston case, DeCastro versus Abrams. I mentioned, I'm sure Google's lawyers, as well written as their motions were, they didn't write most of it. It came from their document bank at the firm. So, especially the legal standard analysis, the they take as much as they can from their document bank, copy paste, and then add the specific facts. It it's the way it's done. I've done it, working criminal defense. I've gone to the more senior attorneys and said, "Hey, give me an example of this type of motion," and change it to fit my needs. It why, reinvent the wheel? Just, um but the point is, like, there's nothing wrong if Floyd, on his own, went to Pacer and found Delete Law's motion and said, "Hey, that looks good. I'm going to plagiarize it." But there is a very big problem when Delete Lawz gives it to him and says, "Here you go. I've got most of a motion written for you." That's the unauthorized practice of law. And it's even worse if Delete Lawz helps him prepare it and files it. And it's bad, 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 bad. Now, why do I mention that? Well, it's because we have two new motions in filed by the wonderful Craig Anderson at Marquis Auerbach, the same defense lawyer as in DeCastro versus LVMPD, which, it's a real galaxy brain move on the part of Delete Lawz to submit the exact same motion, almost the exact same complaint under two different names in the same jurisdiction so that the same lawyer is going to see it. Like, if he had filed this in Reno, he probably would have got away with it if he had put Floyd up to getting arrested in Reno. But he did it in Vegas, in the same precinct where he did. And I mean, and I also mentioned a couple weeks ago, July 3rd, I went to my mom's church, 4th of July barbecue, specifically because I wanted to talk to the one attorney who I've known him forever. I've known him since I was 6 years old. He's got a son my age. And he works for the Salt Lake County district attorney. He's one of the top civil attorneys there. And I mentioned these cases in Vegas and the Ironton case. And I asked him because you know Ironton and even Lawrence County, they don't have big legal departments. They like Lawrence County might have 3 attorneys in the county attorney's office. It's small. So it makes sense hiring outside counsel. But I mentioned to him I'm surprised that Vegas did. And I asked him, what does Salt Lake County do? Because it Salt Lake County is a little bit smaller than Clark County, I think, in population, but the metro area, Ogden to Provo, is slightly bigger than the Vegas metro. Of course, that's excluding tourists because that really increases Vegas's overall, population at any given time. And he was surprised too because they in Salt Lake County very rarely do they farm these out to private attorneys. So it surprised me. But then there are small jurisdictions here that in the municipal court, even in Salt Lake County, so like Murray and I think I don't think West Jordan does, but I think Taylorsville, a couple others, their prosecutors work for a private firm that does prosecutions in justice court. So it's just kind of weird. But that's enough rambling. So the motions we got, well, looking at the docket, it looks like there's 4, but one of them is just the certificate of interested parties filed by Vegas. And then we have the motion to dismiss at 12B6, which I'm slightly surprised there isn't a 12B2 because from what I've seen, I don't know that they've actually been served, but of course, Craig Anderson knows better than I do. But and then 10 and 11 are actually the same motion. Well, it's the same long motion, but they're asking for 2 separate things. So it was posted twice, and one is motion to preclude Jose de Castro from practicing law without a license. And the other is motion to strike the complaint because it was prepared by Jose de Castro. So that's one document, but entered twice. And I mentioned I don't know that they've been properly served because Floyd sent in this summons. It's filed and it's signed by the clerk of court, but the proof of service is empty. So it's possible that the one that actually was received wasn't empty, or that they were actually served, but Floyd is a moron and didn't fill in the proof of service. But either way, I'm not sufficiently convinced that they have been served, so I think I'd be doing a motion to dismiss for failure of process, failure to serve a summons. But like I said, I just they know better than me because they have the actual documents. I just have what's on Court Listener through Pacer. But that being said, so I'm going to go out of order and I'm going to do the fun motion, the motion to preclude and motion to strike. See where I am at the end of that, and then maybe do the motion to dismiss. But if not, we'll just come back to that one later. So with that, let's jump to the document, make it bigger, full screen, and we have defendant LVMPD's motion to preclude Jose de Castro from practicing law without a license and to strike plaintiff's complaint as an improperly filed pleading. Defendant, Las Vegas Metropolitan Police Department, by and through their attorneys of record, Marquis Auerbach, hereby file their motion to preclude Jose de Castro from practicing law without a license and to strike the plaintiff's complaint as improperly filed pleading. This motion is made and based on the attached memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed by counsel at the time of hearing. And I hope that Craig Anderson has also made a formal complaint to the Nevada bar, to the committee that basically reports to the Supreme Court of Nevada. I assume it's the same in Nevada as it is in Utah, as it is in pretty much every state. The Supreme Court of the state regulates the practice of law, and the state bar basically takes the complaints and refers it to the Supreme Court and prosecutes it to the Supreme Court. So I hope that Craig Anderson has made that formal complaint, because that'll be fun. Memorandum of Points and Authorities. Introduction. This case arises out of an incident between plaintiff Floyd Wallace, a known First Amendment auditor, footnote 1, and several LVMPD officers, which occurred on May 10th, 2023. Let's look at footnote 1. First Amendment audits are a social movement that involves photographing or filming from a public space to test constitutional rights, particularly the right to photograph and record in a public space. If the encounter results in an actual or perceived violation of the auditor's First Amendment rights, the video is posted on YouTube and the auditor files suit. The auditors are purposefully confrontational and provocative. See, e.g., Brown versus Besnin. Yeah, I apologize to, I'm assuming, the Armenian people, because I cannot pronounce that name. But that's from the District of Arizona in March of 2023. On that date, plaintiff went to the employee parking lot of LVMPD's Spring Valley Command Substation, located at 8445 Eldora Avenue in Las Vegas, to record vehicles entering a gate marked "Police Personnel Only." Plaintiff would not only record the vehicles, but would also walk right up to the gate while it was open. Plaintiff knew he was filming a restricted area because it was obvious based on the sign. And that's from the complaint. I mean, it says complaint at 19. Let's. This is from Floyd's complaint, the general factual allegations, paragraph 19. After plaintiff had stopped on the public side of the gate and was filming, a man in street clothes exited the police interceptor vehicle and asked plaintiff what he was doing. Plaintiff did not answer, and the man told plaintiff that it was a restricted area behind the gate, which was obvious based on the sign. There you go. Straight from Floyd / Jose's mouth. Also concerning was the fact that plaintiff had covered his face with a mask. The officers found plaintiff's behavior suspicious. Not only was plaintiff wearing what appeared to be a ski mask in Las Vegas in 90+ degree weather, that's Fahrenheit for all my non-US friends, so think 35 degrees or so, because that's about what May in Las Vegas would be. Certainly not ski mask weather. But he was also wearing wearing glasses and a red hoodie in May in Las Vegas. Mr. Anderson, Esquire, finds that as ridiculous as I do. It's May in Las Vegas. I've never actually been to Vegas in May, but my sister lived in Vegas. And so when she got married, we went end of June, and it was 117 degrees. It was that was awful. I cannot handle the heat anymore, and that was awful. But then, late September, it was 90 plus. I went for a concert in April. It was 90. I mean, I drove through on the way home from California, from Orange County. We drove through at midnight, and it was 100 degrees. That was probably August, and I couldn't live in Vegas. At least not in the summer. When someone asked plaintiff what he was doing, he refused to answer. Due to plaintiff's suspicious behavior, police officers detained plaintiff on reasonable suspicion. Delete Lawz seems to think it needs to be probable cause. They need reasonable suspicion. That's a lower standard. Thereafter, plaintiff was arrested for attempted trespass and searched. As a result of this arrest, plaintiff filed the subject complaint on May 24th, 2024. Concurrent with this motion, defendant LVMPD is filing a motion to dismiss the complaint. This motion seeks to address the fact that non-attorney Jose de Castro, another First Amendment auditor, is drafting plaintiff's pleadings and directing this litigation. De Castro is also suing LVMPD. Plaintiff's complaint is almost identical to the complaint filed by De Castro, in which both complaints incorporate the exact same causes of action, language, and even typos. I mentioned one of those typos. The eighth cause of action was the cause of action. Let's look at footnote 2. See generally a true and correct copy of De Castro's First amended complaint, which is attached here too as Exhibit A. Do you know what you never want to happen? You never want your complaint to be an exhibit in a different legal matter. Generally, that's the finding out part of effing around. Thus, LVMPD feels compelled to file the instant motion to preclude De Castro from engaging in the unauthorized practice of law in the future. Statement of facts. De Castro has clearly assisted plaintiff in the preparation, drafting, and filing of his complaint against the LVMPD defendants. And now, I should mention, actually, going back, you'll notice all of the citations here are to Floyd's complaint. This isn't the motion to dismiss. So Floyd's allegations are not taken as true for this motion. So that's just the standard for a 12b6. So that's the other motion that was filed concurrently with this. So just, I don't know that that's going to come up, but keep that in mind as we look at this, because we don't have to go by Floyd's facts for this, because this isn't about the cause of action. This is about the motion to strike and stopping Delete Lawz from practicing law. I mean, I really look forward to the response to this, because it's either going to be written in crayon by Floyd, or it's going to be Delete Lawz saying nope and just digging his hole further. So I really look forward to that. Comparing both complaints side by side, it is obvious De Castro has engaged in the unauthorized practice of law by assisting plaintiff in drafting and filing his complaint against LVMPD. And plaintiff has only switched out some of the facts alleged in the complaint to fit his own narrative. The glaring similarities between the two complaints are illustrated side by side in the table below. And I really appreciate this from Craig Anderson, because one of the reasons my last couple of videos went so long, well, I do ramble, but other than that, it was because I was constantly going back and forth from the complaint to the opposition, to the motion to dismiss, to the opposition to the motion to dismiss, and just back and forth, comparing the facts between them. And lucky for us today, Mr. Anderson has done that for us and put it side by side in a nice table. So thank you, Mr. Anderson. So from De Castro's complaint, I, plaintiff, A member of the press who specifically records police interactions was recording a police interaction outside of a Roll and Smoke barbecue in Southwest Las Vegas. In plaintiff's complaint, I, plaintiff, a black member of the press who specifically records police interactions, was recording a police officer interaction outside of the Spring Valley Command substation in Southwest Las Vegas, Nevada. And those are footnote 3 and footnote 4. And those are just referencing where in the exhibit, which is DeCastro's complaint, or in Floyd's complaint. These are just citations. But the court should note that plaintiff was not actually recording a police officer interaction in this case, but rather a secured gated area of the police station. Well, I mean, not to quibble with Mr. Anderson, but Floyd was interacting with the police, so in a way he was recording a police interaction. He just wasn't recording an existing police interaction with a non-party. So either way, from DeCastro's complaint, sadly, the abusive treatment plaintiff endured for merely asserting his rights and recording the police is not unusual or surprising. This civil rights action seeks to vindicate plaintiff's constitutional and statutory rights and hold the officers and their department accountable for biased policing practices and the policies or absence of policies that resulted in these practices. This section is copied verbatim in plaintiff's complaint, in Floyd's complaint. Going back to Delete Lawz, the parties section lists out plaintiff DeCastro and defendants LVMPD, the state of Nevada, and the officers involved in that specific incident. In Floyd's, plaintiff's parties section is almost identical, only switching out the names of the officers involved in this incident. In DeCastro's, well, this is in DeCastro's and Floyd's because this section is identical, copied verbatim in Floyd's. This court has jurisdiction over this action pursuant to 28 U.S.C. section 1331 and 1343 A3 and 4 because it arises under the Constitution and laws of the United States, and it is being brought to obtain compensatory and punitive damages for the deprivation under color of state law of the rights of a citizen of the United States that are secured by the United States Constitution pursuant to 42 U.S.C. sections 1981, 1983, and 1988. This court has supplemental jurisdiction over the claims arising under Nevada law pursuant to 28 U.S.C. section 1367A. This court is the proper venue pursuant to 28 U.S.C. section 1391B2 because the events giving rise to the claims occurred in the county of Clark in Nevada, which is in the U.S. District of Nevada. Next section, Delete Lawz, says, as a result of defendant's actions, plaintiff suffered a deprivation of his rights and liberties, sustained physical injuries, and suffered physical pain, mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. Floyd's, on the other hand, says, as a result of the defendant's actions, plaintiff suffered a deprivation of his rights and liberties, suffered mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. So basically, it's just missing that Floyd doesn't have a boo-boo on his elbow. The next section is copied verbatim by Floyd. The defendant's behavior did not follow LVMPD's use of force policy and interactions with the public policy. Moving on to the next section, Delete Lawz says plaintiff is informed and believes and intends to prove after conducting relevant discovery that defendant's actions in detaining and or arresting plaintiff, using force on him and illegally searching him and his belongings was motivated largely or entirely by the following. 1. Plaintiff's position as a member of the press that records police interactions for, and I notice this to this point is identical to Floyd's, but I'm guessing there's a difference once we go through the page break. So, 1. Plaintiff's position as a member of the press that records police interactions for accountability and that was engaging in this First Amendment protected activity. 2. Plaintiff's negative viewpoint of the police who all contribute or hold silent, the thin blue line, about police brutality. And or 3. Plaintiff's verbal protestations of the defendant's actions and plaintiff's accusation that the defendants were harassing him. Indeed, as shown on the video footage captured by plaintiff's cell phone and the video footage plaintiff expects to obtain from the defendant's body cams, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the detention and or arrest, except excessive use of force and subsequent searches. Therefore, there is a strong inference that the defendants were in fact motivated by one or more of the three factors enumerated above. And for Floyd's, we'll just start at 2 because that's basically where the differences start. So 2, plaintiff's negative political viewpoint of police. He leaves out the thin blue line. 3, plaintiff's skin color. And or 4, plaintiff's verbal protestations of the defendant's actions and plaintiff's accusation that the defendants were harassing him. Indeed, as shown on the video footage captured by plaintiff's cell phone and the video footage that plaintiff expects to obtain from the defendant's body cams, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the excessive force used, detention and or arrest and subsequent searches. Therefore, there is a strong inference that the defendants were in fact motivated by one or more of the 4 factors enumerated above. And Mr. Anderson adds, the court should note that even the sporadic placement of the apostrophes in this section are the same in both complaints. So Delete Lawz bad punctuation holds. This next section is copied almost verbatim in plaintiff's complaint, even down to the typos, which the court should note that the 8th cause of action is misspelled as 8th in both complaints, missing an H. The cause of action section outlines 10 causes of action for 1, 42 U.S.C. Section 1983, 4th Amendment, 2, 42 U.S.C. Section 1983, 14th Amendment, 3, 42 U.S.C. Section 1983, First Amendment, 4, 42 U.S.C. Section 1983, Monell and supervisor liability, 5, 42 U.S.C. Section 1981, 6, assault, 7, battery, 8, false arrest and imprisonment, 9, invasion of privacy, and 10, negligence. Next section, plaintiff's, meaning Floyd's, prayer section is almost identical, with the only difference being that plaintiff's request for punitive damages is $2 million instead of $5 million. Apparently, Delete Lawz is deserving of $3 million more than Floyd because of his ouchie. And so both of them say, plaintiff prays for damages as follows. A, for compensatory damages in an amount according to proof. B, for punitive damages in the amount of $5 million for Delete Lawz, $2 million for Floyd, or in an amount sufficient to punish defendants' conduct and deter similar conduct in the future, pursuant to 42 U.S.C. Section 1983. No punitive damages are sought against defendant Nevada. C, all applicable statutory penalties. D, for attorney's fees pursuant to 42 U.S.C. Section 1988. E, for costs of suit. F, for such other and further relief as the court deems just and proper. And I think Mr. Anderson has missed out on this section, actually, because I would have actually pointed out that the difference here is Delete Lawz is pro se, so he's not entitled to attorney's fees. But B, Floyd is also pro se and not entitled to attorney's fees, but he's especially not entitled to attorney's fees for non-attorney Jose De Castro. So I think it's time to bring out the nickname again. Jose Maria Antoinette. He wants to have his cake and eat it too. He wants to be pro se, but compensated as an attorney. Doesn't work that way. In addition to the evident similarities between the two complaints, De Castro has openly spoken about plaintiff's case on his YouTube channel, Delete Lawz, where he said that he wanted to send a real quick message to the Las Vegas Metro Police Department. The federal civil rights lawsuit continues, and you will be held accountable, in bold, for wrongfully arresting Mr. Floyd Wallace. Footnote 24. See De Castro's Delete Lawz YouTube video dated June 10th, 2023, video 1, at this URL at 259 through 310. De Castro adamantly stated his distaste for police officers, stating, Las Vegas Metro Police Department has got to understand you will not arrest journalists, and if you do, I will be damn sure that you are held accountable for what you do to people. De Castro further indicated him and Wallace did an audit together, which was kind of nice, because it was nice to have someone there that was unafraid of these rap boot thug pigs. De Castro claims to have helped Wallace raise the funds to file his lawsuit because during his video, he gave a big thank you to everybody who helped crowdfund the cost of Mr. Wallace's lawsuit. De Castro even admitted he went to the federal building as a courier for Wallace to file this lawsuit. And yet they weren't allowed in at first because they had cameras and I can't remember. Either way, they had to go back the next day. But speaking of crowdfunding, go support Professor Scofield. Once plaintiff's complaint was filed, De Castro went through the complaint online and continued to provide legal advice to his viewers on how to draft and file a legal pleading such as plaintiff's complaint. Let's see, footnote 26. All right, it's still just references to the video. De Castro specifically advised his viewers on how to draft the caption, introduction, parties, jurisdiction, and venue, and general factual allegations of the complaint if his viewers ever wanted to sue. De Castro further stated, if they arrest journalists here, I'll seek them out and work with them and help them. The court should note DeCastro is not a licensed attorney and therefore is engaging in the unauthorized practice of law. It appears both DeCastro and plaintiff have an axe to grind with LVMPD, and DeCastro has assisted plaintiff in bringing a trumped up, frivolous suit plaintiff will be pursuing vigorously, where there was reasonable suspicion for plaintiff's detention and probable cause for his arrest. DeCastro has not only been assisting plaintiff with his case, but also appears to be soliciting his services for any of his viewers who may be arrested in the future, which means this could be a continuous issue moving forward. Thus, the court should issue an order to permanently preclude DeCastro from the unauthorized practice of law. It's too bad he doesn't have the references, at least I don't think, to him helping Eunice Lofty in Texas very poorly, or helping DUI Deborah Rogers, or the what's her name? The one with the baby in her belly. I don't remember her name, but I think she's the one that very foolishly gave him power of attorney and quickly found out that didn't work. Either way, it would be wonderful if he had included that to show, hey, this is a pattern, that this is his pattern of conduct, his practice. He's a habitual fake attorney. You need to send a message here. And I really hope it's been sent to the Supreme Court of Nevada. Legal standard. Pursuant to 28 U.S.C. Section 1654, parties may plead and conduct their own cases personally. In an action brought by a pro se litigant, the real party in interest must be the person who has the right to be enforced. Simon versus Hartford Life, Ninth Circuit, 2008. Although a non-attorney may appear on his own behalf, that privilege is personal to him. Citing McShane versus United States, Ninth Circuit, 1966. A non-attorney has no authority to appear as an attorney for people other than himself. Russell versus United States, Ninth Circuit, 1962. Collins versus O'Brien, DC Circuit, 1953. Cert denied in 1954. So Collins versus O'Brien went to the DC Circuit, but it was denied by the Supreme Court, meaning that decision stands. The Supreme Court basically refused to hear it, so that's in effect endorsing the DC Circuit's decision. The Nevada Supreme Court, in Ray Lerner, from 2008, cited several general definitions of the term the practice of law, including the Ninth Circuit's definition in Taub versus Weber. Although in Utah that would be Weber, because we have Weber State University and Weber County, which is where Ogden is, about 40 minutes north of Salt Lake. But Taub versus Weber, Ninth Circuit, 2004, that the practice of law means the exercise of professional judgment in applying legal principles to address another person's individualized needs through analysis, advice, or other assistance. And that's from In Ray Lerner from the Nevada Supreme Court, 2008. Legal argument. The court should issue an order precluding Jose de Castro from practicing law without a license and providing unauthorized legal assistance in this case and other cases. Pursuant to NRS 7.285(1)(a), a person shall not practice law in the state of Nevada if that person is not an active member of the State Bar of Nevada. That includes me. I can't practice in Nevada, although, well, or otherwise authorized to practice law in Nevada. So you'll notice that's active member of the State Bar of Nevada or otherwise authorized to practice law in Nevada. So I'm not a member of the State Bar of Nevada, so I can't generally practice there, but I can most likely be a pro hoc vice attorney, and some courts like bankruptcy, which is federal, and but basically for some things it's real easy to pro hoc, others less so. State court less so than federal, um, generally. But then even like there are some instances where like the practice in Nevada would be ancillary to my practice in Utah. So, like, if I'm doing the sale of a company that's based here in Utah, so my client is Utah based, but they're selling their company to someone in Nevada, I may have to advise them on Nevada laws for the purpose of that sale. So that's that's a little practice in Nevada, but it's ancillary to my practice in Utah. So it would probably be allowed, but it still might be a good idea for me to get Nevada counsel to advise. So it's actually quite a complex issue. In my blitz to finish my CLE, continuing legal education, a lot of it was actually this year was actually about that. Do we really need state bars? Like with the internet, practice probably should be nationwide, but some of the problems they have is, well, what about the damage fund that basically attorneys, as part of their bar dues, it goes to a fund for people who are damaged by their attorneys by malpractice. And so if I'm licensed in Utah, but and so I'm paying those dues in Utah, but I damage someone in Nevada, which fund does that come out of? Because it's in Nevada, so does Nevada's bar? But I've paid in Utah, so does so that's some of the questions, and which bar sanctions me, Nevada or Utah? But then if Nevada's bar sanctions me, Utah's bar would have to reciprocate anyway. So it's just, I know this is a fascinating tangent, but I had to sit through it, so now you have to. But those are some of the questions they're trying to answer for the future. So practice may be more than statewide in the future. I won't say near future, but it could be. So a person who violates NRS 7.85 or 7.285(1) may be found guilty of a misdemeanor for the first offense, a gross misdemeanor for the second offense, and a Category E felony for any third or subsequent offense in the preceding 7 years. NRS 7.285(2). Now, me being a Utah attorney, I'm not quite sure, misdemeanor, gross misdemeanor, category E felony, because that's not the way we do it here in Utah. We have, infractions, and then we have A, B, and C misdemeanors, A being the worst, C being the least, and then we have felony 1, 2, and 3. So we don't have E felonies, but I'm guessing that the felony versus misdemeanor carries over, and you know, generally felony is maximum punishment of a year or more. Um, the overarching reason for requiring that only lawyers engage in the practice of law is to ensure that the public is served by those who have demonstrated training and competence. Boy, Delete Lawz doesn't have competence. And who are subject to regulation and discipline. What did I mention on my tangent? One of the reasons that they're having trouble, even though the regulators want to expand nationwide, is the question of regulation and discipline, and making the clients who are damaged whole. So that's the issue. Like, that's the issue, stopping the unauthorized practice of law by non-lawyers, but it's also the question for lawyers practicing out of state, regulation and discipline. I mean, think about Leonard French, the Lawful Masses with Leonard French. Great channel. You guys should go subscribe. He has a years-long series on a copyright attorney out of New York. He's basically a copyright troll. And I said copyright attorney, but I don't think he is anymore, because see Leonard French. Leibowitz, who basically, he's got a string of punishments all across the country. So, but moving on. An individual engages in the unauthorized practice of law when he performs activities customarily executed by licensed attorneys, citing Arteaga versus Hutchins Drywall, Inc. from the District of Nevada in 2011, citing Lerner. Some examples of activities constituting the unauthorized practice of law include evaluating legal claims, filing documents, and appearing in court on behalf of someone else. Nevada law makes it clear that giving legal advice and exercising legal judgment constitute the practice of law, citing Pioneer Title Insurance and Trust versus State Bar of Nevada. And that's going to be Nevada Supreme Court, 1958. In Sproul versus City of Surprise, the District Court of Arizona had to rule on a similar issue as the one described herein. And that's Sproul versus City of Surprise, District of Arizona, Federal Court, 2012. In Sproul, the defendants, City of Surprise and Surprise Police Department, filed a motion to preclude Ammon M. Sproul from practicing law without a license. Defendants believed that Ammon Sproul 1, had been acting as an unauthorized legal representative for his son, Ammon Sproul II, Sproul 2. Because parents can't represent their kids in court, even minor kids. So if your kid's in juvenile court, you can't speak for them. They have to have a juvenile attorney. They're most jurisdictions should have specialized juvenile public defenders, but Some it might just be the regular public defender, but either way, you can't if your 17-year-old kid is in a car accident and sued, you can't speak for them in court. Of course, the reality is they're going to be suing you as well, probably because you probably own the car or are on the insurance or whatever. So it's really a question for the insurance company, probably. But either way, you can't represent them. But Sproul 1 had been acting as an unauthorized legal representative for his son, Sproul 2, because it appears that Sproul 1 assisted in the preparation of the complaint. The court determined that since Sproul 1 was not a licensed attorney, that he was precluded from practicing law on behalf of his son. Here, DeCastro is a self-proclaimed constitutional law scholar who has been assisting plaintiff by providing legal advice that attempts to address plaintiff's individualized needs based on the incident that occurred on May 10th, 2023. The obvious similarities between DeCastro and plaintiff's complaint demonstrates DeCastro helped plaintiff draft a legal pleading, which is a function customarily executed by licensed attorneys. Moreover, DeCastro has openly admitted to going to file the lawsuit on plaintiff's behalf. The Arteaga court has provided both of these services in and of themselves constituted an unauthorized practice of law. To take it a step further, DeCastro openly discussed plaintiff's complaint online for his YouTube audience, informing them on how to draft and file the different sections of a complaint, which arguably is DeCastro giving unsolicited legal advice to subscribers that view his channel. DeCastro has even mentioned if any journalists found themselves to be arrested, he would seek them out to help them file a lawsuit. Therefore, it is clear DeCastro has no intention of stopping with plaintiff, but intends to offer his services and provide legal advice to any individual who may find themselves in a situation where they believe they were wrongly arrested by the police. Thus, just like in Sproul, where the court granted the defendant's motion to preclude Sproul 1 from practicing law without a license because it found Sproul 1 had assisted Sproul 2 in the preparation of his complaint, the court should rule the same here and grant this motion in its entirety. Now, you'll notice that Mr. Anderson basically says, yeah, DeCastro intends to keep this going. It would have been great if he had included, hey, he's also done this in the past for Eunice Lafty and DUI Deb and Baby in Her Belly and whoever else. It's a pattern, and he clearly intends to keep going because he said so on his video. And it reminds me, for those of you who know the YouTube channel, I'm sure most of you do, because if you're here, you probably watch the true crime channels as well. But the Casual Criminalist, hosted by Simon Whistler. I swear, Simon Whistler has half the videos on YouTube between all of his channels. But on the Casual Criminalist, he keeps a list of rules for criminals. One of them is don't write down your crimes. And, that's rule 1. Rule 1B is don't film your crimes. Delete Lawz broke that rule here. He filmed it and put it on YouTube talking about the case and how they prepared it, and if you want help too, just contact him. Simon Whistler would be appalled. Next section, B. If the court finds that DeCastro has provided unauthorized legal assistance in drafting and filing plaintiff's complaint, the court should strike the complaint as improper. Oh boy, if the court strikes the complaint, I look forward to, well, in reality, it probably just ends there because I don't think that Floyd actually cares. I think it's really that Delete Lawz in like invited Floyd to Vegas with the intention of getting him arrested to bolster his case, basically, so that Floyd sues and then he can, in his case, go, see, this is a pattern of practice by the LVMPD. They arrest journalists. So I don't think he actually gives, like, he does not care about Floyd. He just wanted to be able to crow in his own suit that they arrest journalists. See, so me alleging there's, for the Monell claims that they have bad policies, it, it's just proven by this. So I doubt that Floyd cares enough to actually refile, but if he does, I look forward to his complaint written in crayon. Where a person has engaged in the unauthorized practice of law and filed pleadings in an action, the first appropriate remedy is for the court to strike the improperly filed pleadings. That's citing Henry versus Rizzolo from the District of Nevada in 2009, which itself cites Hamilton versus Illinois Central Railroad Company from the Southern District of Illinois in 2008, which said striking affidavits submitted through the unauthorized practice of law and the Unalaktigo band of the Nanticoke Lenni Lenape Nation. My apologies to the wonderful tribe. Versus New Jersey from the District of New Jersey in 2007, which struck plaintiff's motion for sanctions as its filing by a person without a license to practice law constituted unauthorized practice of law. Consistent with striking the improperly filed pleadings, the party should also be prohibited from using any additional services of the non-attorney. Should he continue to do so, he would be leaving himself open to having more severe sanctions imposed. More severe sanctions. And now, I don't like the way this was written, just because the he here is a little ambiguous. Although I think it's referring to Floyd, because the party, so that would be Floyd, should also be prohibited from using any additional services of the non-attorney, and should Floyd continue to do so, as in continue to use the unauthorized services of a non-attorney, Floyd would be leaving himself open to having more severe sanctions imposed. So more severe sanctions would be, instead of just having the offending filings struck, monetary sanctions or dismissal with prejudice, or those are more severe sanctions. But I mentioned this is a little bit ambiguous because the he facing more severe sanctions could also be Delete Lawz. It could go from a misdemeanor for the unauthorized practice of law to a gross misdemeanor for the unauthorized practice of law, because that would be the second instance. If you kept it going, the third instance would be a Class E felony. In addition, the federal rules of civil procedure provide the time for answering a complaint is extended by a motion under Rule 12. That cites Carter versus Penzone, District of Arizona, 2019, citing Federal Rule of Civil Procedure 12A4. Rule 12 includes motions to dismiss, 12B, motions for judgment on the pleadings, Rule 12C, and motions for a more definite statement, Rule 12E, and motions to strike, Rule 12F. Since the instant motion includes a motion to strike under Rule 12F, the time to answer the complaint should be extended until the court reaches a determination on these issues. Furthermore, the court determines if the court determines DeCastro has engaged in the unauthorized practice of law, then pursuant to Rizzolo, the first appropriate remedy is for the court to strike the improperly filed complaint. Additionally, if such determination is made, then the court should also prohibit plaintiff from using any of DeCastro's legal advice moving forward. Then, if the plaintiff continues to receive any legal advice or services from DeCastro that are not normally provided by a licensed attorney, then the court should sanction plaintiff for knowingly receiving such unauthorized legal services. Okay, so I was right. It was saying further sanctions on Floyd. Conclusion. Accordingly, LVMPD respectfully requests this court grant its motion to preclude Jose DeCastro from practicing law without a license and to strike the complaint as an improperly filed pleading in its entirety. At a minimum, this court should issue an order prohibiting DeCastro from participating, assisting, or providing legal advice to plaintiff in this case. Dated this 17th day of July, 2023, Marquis Auerbach, signed Craig R. Anderson. And it was served to Floyd at by mail to College Station, Texas, because let's look at the docket. Actually, case randomly assigned, advisory letter, receipt of filing fee, ordering him to pay the filing fee, receipt of filing fee, order about when service must be effectuated by, the complaint, summons, and then the instant motions. So Floyd has not actually requested the ability to provide service or to have access to ECF filing, I should say. So he's receiving service by mail in College Station, Texas. I don't think that these Las Vegas judges are going to be as forgiving, shall I say, as the Southern District of Ohio in DeCastro versus Wagner, because, in that, Delete Lawz basically isn't monitoring his Santa Monica mailing address. So he used the excuse for missing deadlines. Well, I never saw them because I didn't see them in the mail. Well, this is Magistrate Nancy Copy. That's a different magistrate than in DeCastro. Although Andrew P. Gordon, I believe that is the same judge. Let's look. So yeah, DeCastro versus LVMPD is assigned to Andrew P. Gordon and Magistrate Judge Elena Ucha. So same district judge, different magistrate judge, but judging from that, they're not going to take his nonsense. So my question is, Is Floyd in College Station? Is he going to receive service of this? I mean, he's a passport bro. Is he back in Africa or in Thailand? I- Is is he with oh, it would help if I remembered the name to make my joke. Um, but the woman in Thailand that he couldn't pronounce her name, so he gave her an English name because that's what you do. So is he with Jane in Thailand? So either way, that is the motion to strike and to preclude Jose de Castro from practicing law. And you see, this is the first exhibit, the Delete Lawz, Jose de Castro versus LVMPD. That's a really bad look. But I think we made it through that in decent enough time that let's take a look at the motion to dismiss filed by LVMPD, sticking with, of course, News Now Future Statistic versus LVMPD, or News Now Passport Bro. Defendant, Las Vegas Metropolitan Police Department, by and through its attorney of record, Marquis Auerbach, hereby files its motion to dismiss. This motion is made and based upon the memorandum and points and authorities, the pleadings and papers on file herein, and any oral argument allowed at the time of hearing, dated the 17th day of July, 2023, Marquis Auerbach, signed Craig R. Anderson. Memorandum of Points and Authorities. Introduction. This motion requests dismissal of all claims against defendant LVMPD. At its core, this is a 42 U.S.C. Section 1983 false arrest claim. Plaintiff Floyd Wallace admits on May 10th, 2023, he covered his face with a black mask, traveled to an LVMPD substation, approached an area gated off to the public, and began filming inside the restricted area. In response, several LVMPD officers detained Wallace and questioned him regarding his actions. Wallace admits he refused to answer the officers' questions and initially refused to even identify himself. The officers arrested Wallace for attempted trespass. And I've said it before, I'm going to say it again. The arrest was fine. They had the probable cause. The arrest was fine. But the arrest was not necessary. So I have no problem in general that the prosecutors decided not to press charges because, I mean, attempted trespass, that's not worth their time. It just isn't. It's, but I still fully believe there was probable cause. So that's the standard here. It's not did were you convicted? It's was there probable cause? And even for stopping him, it was there reasonable suspicion? And I should also mention, I mentioned the opposite on the previous motion. This one, as a motion to dismiss, remember 12B6, we we have to go by the Rule 8B standards of pleading, and the Twombly and Iqbal are best friends. So for the purposes of this filing, we have to take Floyd's well-pled facts as true for the purposes of this motion and this motion only. Well, and his opposition to it, of course, um, but conclusory statements misstatements of the law, implausible allegations, we don't have to take as true, according to Twombly and Iqbal. And the merely reciting the elements of a cause of action is not pleading that cause of action. You've got to lay out facts. That's going to be important, especially in the Monell section. So that's the standard we have to look at this through. As a result of these pled facts, Wallace sued LVMPD and several officers alleging both federal and state law claims. With respect to defendant LVMPD, Wallace alleges a federal law Monell claim, footnote 1, see Monell versus Department of Social Services from the Supreme Court in 1978, and includes it in the state law claims against its officers under a theory of respondeat superior, meaning if an employee does something, the employer is responsible. Unless, of course, the employee was on a frivol or a frolic, or I can't remember exactly, but the exception is kind of ridiculous sounding. So basically, like if a delivery driver decides, if they have a prescribed route to drive, but there's heavy traffic, so they take a different route and get in an accident. Well, they're still in the line of their duty, so respondeat superior would still apply. But let's say he drives 10 miles out of his way to go to McDonald's for lunch and gets in an accident. Well, respondeat superior might not be applicable there, because that was a frolic. That was the employee taking an independent journey in the employer's vehicle. And so, going to 10 miles to McDonald's isn't part of the job. Whereas if if McDonald's is on the prescribed route and, the employer allows them and says, yeah, you're allowed to stop and get lunch on your way. Once you've completed your delivery, go do it, then it might still apply. So, yeah, respondeat superior is kind of an interesting concept. And let's see. So I'm having a brain fart here. I'm not sure what the abbreviation COMPL is supposed to be, but it is at the 4th, 6th, 7th, 8th, 9th, and 10th causes of action. This motion seeks dismissal of all claims against LVMPD pursuant to Federal Rule of Civil Procedure 12b-6. With respect to Wallace's federal law claim, Wallace alleges LVMPD is responsible for its officers' unconstitutional conduct because it has unconstitutional policies, practices, and customs that allowed for and ratified their behavior. This federal law claim fails for two reasons. First, the complaint's facts do not state a constitutional violation. Second, even if the complaint states a constitutional violation, it does not state sufficient facts to support a Monell claim, as the complaint only contains boilerplate allegations and conclusory statements. Remember Twombly and Iqbal. That's not enough. With respect to Wallace's state law claims, he alleges LVMPD is responsible for the officer's state law torts under a theory of respondeat superior. Similar to the federal law claims, the complaint fails to plead facts supporting any of the alleged state law torts. And you'll notice here, in DeCastro versus LVMPD, it's a partial motion to dismiss because they're not seeking, at least in that motion, that they will in a summary judgment motion relatively soon, but they're not moving to dismiss the assault, battery, and one of the other claims. In this, they are. You, do you know what the difference is yet? I haven't read this, but I know the difference. Pause this, go to the comments, and like and subscribe while you're there. But go to the comments and tell me, before I tell you, why is this different? Why are they moving to dismiss all of the claims against Floyd or from Floyd, whereas they're only moving to dismiss some of the claims from DeCastro? You ready? You already left your guess down below? It's because Delete Lawz said they punched him in the nuts, and Floyd didn't. So, because for the purposes of a 12b6, they have to take that as a factual allegation. They have to accept it as true for the purposes of the 12b6. He was punched in the nuts. We know he wasn't, but for this purpose, he was punched in the nuts. And that's enough of a factual allegation to survive a 12b6. So they're not even arguing it. Whereas on a summary judgment, they're going to have an affidavit submitted by the officers, supported by body cam, and then Delete Lawz will submit his affidavit and body cam, and it'll compete, and it'll probably be dismissed. But either way, Floyd hasn't alleged he was hit in the nuts. So there is no fact to support the assault and battery and whatever the other claim was that they're not moving to dismiss against DeCastro, but they are against Floyd. So Floyd hasn't alleged anything for those. That's why they're moving to dismiss them. Where was I? Okay, I think I was. Yeah, I just finished the boilerplate allegations and conclusory statements. With respect to Wallace's state law claims, he alleges LVMPD is responsible for the officer's state law torts under a theory of respondeat superior. Similar to the federal law claims, the complaint fails to plead facts supporting any of the alleged state law torts. They didn't hit him in the nuts. Background. Plaintiffs pled facts. According to Wallace's complaint, on May 10th, 2023, he went to LVMPD's Spring Valley Command Substation to record police officers. Wallace covered his face with a black mask. He then positioned himself at a gate with signs clearly prohibiting public access. Wallace then began filming the arrival of police vehicles. Eventually, a person in plain clothes approached Wallace and asked plaintiff what he was doing. Wallace ignored the individual and never said a word. Wallace eventually returned to a public sidewalk. While on the sidewalk, Wallace was stopped by multiple uniformed police officers. An officer approached Wallace with a drawn gun, instructed to the front of a police car, and handcuffed him. Wallace was told he was being detained on reasonable suspicion because video surveillance showed him trying to enter a gate not open to the public. As the officers frisked Wallace for weapons, he asserted his right not to have his wallet searched and asked for a supervisor. Wallace refused to provide his identity. When the officers threatened Wallace with arrest for obstruction and failing to identify, Wallace provided his name and birthday under threat of arrest. Wallace claims the officers racially profiled him, accused him of being a terrorist and a possible auto thief. Eventually, Wallace was arrested for attempted trespassing. Wallace was transported to jail and released with a citation. Wallace's background. Plaintiff Wallace is a First Amendment auditor. First Amendment auditors are a social movement that involves photographing or filming from a public space, or at least what they claim are public spaces, um, to test constitutional rights, particularly the right to photograph and video record in a public space. If the encounter results in an actual or perceived violation of the auditor's First Amendment rights, the video is posted on YouTube and the auditor files suit. The auditors are purposefully confrontational and provocative. CEG Brown versus Baznanian. Once again, the presumed Armenian name I can't pronounce, from the District of Arizona in 2023. Wallace has sued other police departments and police officers for almost identical behavior as he demonstrated in this case. CEG Wallace versus Taylor from the Fifth Circuit in 2023. Wallace's causes of action. As a result of Wallace's pled facts, he is suing LVMPD and several of its officers, alleging both federal law and state law claims. Specifically, his complaint alleges first cause of action, 42 U.S.C. Section 1983 claims for false arrest and excessive force against defendants Torres, Shoemaker, and McCormick. Second cause of action, 42 U.S.C. Section 1983 and equivalent rights under the Nevada State Constitution for equal protection violations against defendants Torres, Shoemaker, and McCormick. Third cause of action, 42 U.S.C. Section 1983 and equivalent rights under the Nevada State Constitution for free speech retaliation. Fourth cause of action, 42 U.S.C. Section 1983 Monell and supervisory liability claims against LVMPD and Torres. And Monell has footnote 2, which is a citation to Monell versus Department of Social Services of City of New York. Fifth cause of action, 42 U.S.C. Section 1981 for intentionally discriminating against Wallace because of his race and political affiliation and viewpoints against Torres, Shoemaker, and McCormick. Sixth cause of action, state law assault against all defendants. Seventh cause of action, state law battery against all defendants. Eighth cause of action, state law false arrest and imprisonment against all defendants. Ninth cause of action, state law invasion of privacy claim against all defendants. And finally, the 10th cause of action, state law negligence claim against all defendants. This motion requests the court dismiss all claims against defendant LVMPD. These claims include the 4th, 6th, 7th, 8th, 9th, and 10th causes of action. I'm not quite sure why he specified that and left out the 1st, 2nd, and 3rd, because he's requesting all, unless, of course, that was copied. Because, like I said earlier, plagiarize, plagiarize, plagiarize. I'm sure parts of this are taken straight from his motion to dismiss against Delete Lawz. So this may have been a copying error from that, because leaving out the 1st, 2nd, and 3rd. So, like I said, Go ahead and plagiarize, but you've got to make sure you plagiarize right. You've got to make sure you alter everything you need to alter. Legal standards. Our good old friend Twombly and Iqbal, but we're going to have the local Ninth Circuit cases stating the same. Motion to dismiss standards. Under Federal Rule of Civil Procedure 12b-6, a complaint may be dismissed for failure to state a claim upon which relief may be granted. Dismissal for failure to state a claim is a question of law. Citing Jackson versus Southern California Gas Company, 9th Circuit, 1989, and it is appropriate when a plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. That's citing Abramson versus Brownstein, 9th Circuit, 1990, quoting Gibson versus United States, 9th Circuit, 1986. And you'll notice these are all all of these predate Twombly and Iqbal, because Twombly is 2007, Iqbal 2009. So these were made under the old Conley versus Gibson standard. But these are still good law because it's not about the heightened requirements from Twombly and Iqbal saying, yeah, conclusory facts aren't enough. You've got to have some facts. You can't just recite the cause of action, the elements, and conclusory statements. You've got to have some facts. You don't have to have all the facts, but you've got to have some facts. But here it's plaintiff can prove no set of facts in support of his claim. So, and the reality is, I don't actually know. I've never practiced in the Ninth Circuit, but it might be that before Twombly and Iqbal were heard, because I think Iqbal originated in the Second Circuit because Iqbal was arrested in New York City, although it might have been in the DC Circuit before going to the Supreme Court because he was suing John Ashcroft, the Attorney General. So I don't actually know the whole procedural posture. And Twombly, I'm not sure which circuit it rose out of. They both went to the Supreme Court, but it might have been, those might have been heard by the Supreme Court, especially Twombly, which came first, because of a circuit split. So it might be, like I said, I don't know. I'm not from the Ninth Circuit. And they wouldn't have taught this because they just taught the standard we need to know. But it might be the Ninth Circuit always had this heightened level. So there might have been a circuit split, and that might be why the Supreme Court took up the case of Twombly to solve that circuit split. And so the Ninth Circuit might have had this apparently heightened standard of pleading where plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. And that's from 1990. While quoting Gibson versus United States from 1986. So the Ninth Circuit might have had this higher level of pleading, and Twombly was basically the Supreme Court saying, yeah, that's going to be the standard now nationwide. So, and because this isn't in conflict with Twombly, it's still good law, even though it's from before Twombly. The United States. Well, my computer decided it was time to restart midstream, so I'm back. But other than me saying that, you're not going to notice that because I'm going to edit it out. So I really hate editing, but I'm going to give YouTube's editor a try. Just, upload it and then cut it out because I'm hoping that'll be easier. But with that, let's get back to the case. So, the United States Supreme Court has addressed the minimum standards a complaint must meet to withstand a motion to dismiss under Federal Rule of Civil Procedure 12b-6 when measured against the pleading standards set by Rule 8a-2. And I made a mistake earlier. I referred to it as Rule 8a. I'm going to justify it by saying, or I said 8b. When it's 8a-2, I'm going to justify it by saying, well, it's 8ab because the 2 is a b. That's my justification. Either way, while a complaint attacked by Rule 12b-6 motion to dismiss does not need detailed factual allegations, a plaintiff is obligated to provide the grounds of his entitlement to relief under Rule 8a-2, and it requires more than labels and conclusions and a formulaic recitation of the elements of a cause of action will not do. That's from Bell Atlantic versus Twombly, our good friend from the Supreme Court in 2007, which quotes Federal Rule of Civil Procedure 8, Rule 8, and that's just a formatting thing. The court extended the pleading requirements articulated in Twombly, an antitrust case, to all cases. See Ashcroft versus Iqbal in 2009. As a result, factual allegations must be enough to raise a right to relief above the speculative level, on the assumption that all the allegations in the complaint are true, even if doubtful in fact. To satisfy Rule 8a-2, a plaintiff must plead enough facts to state a claim for relief that is plausible on its face. And that's Twombly. And enough facts means every element of a cause of action has to have some factual support. So, like going back to Delete Lawz, him saying they punched me in the nuts, that's some factual support, even though it's doubtful, in fact, because it is doubtful. But it's got to be taken as true for that. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And that's from Iqbal. Where a complaint pleads facts that are merely consistent with a defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. While a court must accept all allegations as true, that tenet is inapplicable to legal conclusions. You hear that? It's inapplicable to legal conclusions. So when Delete Lawz, going back a few videos ago, remember all the times in his opposition to the motion to dismiss, it says in my complaint that they arrested me without probable cause. And so that has to be taken as factual. That's a legal conclusion. Whether there's probable cause is a legal conclusion. So that doesn't have to be taken as true. The court gets to decide the facts. Well, the law, sorry. The court is the decider of law. The jury, although these won't go to the jury, are the deciders of fact. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Ultimately, Rule 8 does not unlock the doors of discovery for a plaintiff armed with nothing more than mere conclusions. Dismissal is proper where there is either a lack of a cognizable legal theory or the absence of sufficient facts alleged under a cognizable legal theory. That's Ballesteri versus Pacifica Police Department, Ninth Circuit, 1990. Monell standards. A Monell claim is a claim for recovery against a local municipality where a government entity could be held liable only when a constitutional deprivation arises from a governmental custom. That's Monell versus Department of Social Services of City of New York, Supreme Court, 1978. In other words, when a municipal policy is the cause of the unconstitutional actions taken by municipal employees, the municipality itself will be liable for those actions. Liability only exists where the unconstitutional action implements or executes a policy, statement, ordinance, regulation, or decision officially adopted and promulgated by municipal officers, or where the constitutional deprivation is visited pursuant to governmental custom, even though such custom has not received formal approval. The court defined custom as persistent and widespread discriminatory practices by state officials. And that's from Monell citing Atticus versus S.H. Dress and Co. from the Supreme Court in 1970. Furthermore, the doctrine of respondeat superior does not apply to 42 U.S.C. Section 1983 claims against municipalities. And that's citing Pembauer versus City of Cincinnati, Supreme Court, 1986, which itself cites Monell. In other words, municipal liability would not be established simply by showing that a municipal employee committed a constitutional tort during the scope of his or her employment. In order for a municipality to be liable, a plaintiff must establish that the wrongful act was somehow caused by the municipality, citing Monell. An affirmative link must exist between the policy or custom and the particular constitutional violation alleged must be shown. That's citing City of Oklahoma City versus Tuttle, Supreme Court, 1985. Moreover, the alleged policy or custom must be the moving force behind the constitutional violation in order to establish liability under Section 1983. Citing Polk County versus Dodson, Supreme Court, 1981, which cites Monell. Causation must be specific to the violation alleged, meaning that merely proving an unconstitutional policy, practice, or custom will not in and of itself establish liability unless the specific injury alleged relates to the specific unconstitutional policy proved. And that's citing Board of County Commissioners of Bryan County, Oklahoma versus Brown, Supreme Court, 1997. Now remember, in this complaint, as well as Delete Lawz complaint, since they're almost identical, they just recite Monell. They recite the Monell factors. It's a list, but it doesn't include any factual allegations. That they just think, well, if we can go on a fishing expedition, we might be able to find something, but that's not allowed. Once each of these elements are met, a plaintiff must also prove that the unconstitutional policy that caused him injury was the result of something more than mere negligence on behalf of the municipality, and was instead the result of deliberate indifference, which is a state of mind that requires a heightened level of culpability, even more so than mere indifference. So that's mere indifference versus deliberate indifference. Well, that sounds an awful lot like in defamation claims, actual malice versus just being untruthful. So this sounds like it's akin to the actual malice standard in defamation. Proof of a single incident is insufficient to establish a widespread custom or policy. And that's, like I said, I absolutely believe this is why Delete Lawz got Floyd to travel to Vegas, because he thinks that this way he gets to say, well, see, they have a policy of going after journalists because, a single incident isn't enough. But look, they went after me, a journalist, and they went after Floyd, a black journalist. That's a policy because it's been done twice. Even though them being journalists has absolutely nothing to do with why they were arrested. To plead a proper Monell claim against LVMPD, Wallace must 1. Identify the challenged policy or custom, which he doesn't do. He just does a list of what could be a Monell infraction. But that's not a factual allegation. That's just a threadbare recital of the elements. And Twombly and Iqbal say that's not nearly enough. 2, he must explain how the policy or custom is deficient. 3, explain how the policy or custom caused the plaintiff harm. And 4, demonstrate how the policy or custom amounted to deliberate indifference, actual malice, deliberate indifference, by showing how the deficiency involved was obvious and the constitutional injury was likely to occur. And that's citing Harvey versus County, or is that city? It's been a while since I've been in the Blue Book. I can't remember if CTY is an abbreviation for county or city. County might have an N in it. I really hate abbreviations, but I hate the Blue Book, the guide for legal citations. It's so awful. It seriously cares whether you italicize a comma or even a period. That's why I didn't do law review. I don't care if a comma is italicized. But either way, that's Harvey versus South Lake Tahoe, Eastern District of California, 2012. And of course, California is in the Ninth Circuit, as is Nevada. And South Lake Tahoe is right on the border with Nevada. Post-Iqbal, a plaintiff cannot solely rely on conclusory factual allegations. Instead, a plaintiff must allege facts, which, if true, show the defendant actually had a constitutionally impermissible policy, practice, or custom. And that's Waggy versus Spokane County, Washington, Ninth Circuit, 2010. And why is that abbreviated CTY, but county is not? An actionable policy or custom is demonstrated by 1, an express policy that, when enforced, causes a constitutional deprivation. 2, a widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Or 3, a constitutional injury caused by a person with final policy-making authority. A mayor, a police chief, a governor, county treasurer. They'd probably, at least for their departments, have final policy-making authority. A patrol cop, even a sergeant, would not. And that's from Baxter versus Vigo County School Corporation, 7th Circuit, 1994, and back to the abbreviation, City of, I'm guessing, of St. Louis versus Prapotnik from the Supreme Court in 1988, and that was a plurality opinion, so probably 4 justices, but then another justice or 2 would have to concur with some of it, making at least this part good law. Legal argument. Wallace's 4th cause of action alleges a Monell claim against defendant LVMPD. Without any specific facts, Wallace alleges LVMPD's customs, policies, practices, and or procedures allowed the defendant officers to commit the following constitutional violations. 1. Unlawful detentions and arrests without reasonable suspicion or probable cause. 2. Unlawful detentions to violate citizens' First Amendment right to verbally criticize and protest the police. 3. Use of excessive force. 4. Unlawful searches of persons. 5. Racial profiling. 6. Failure to train. 7. Failure to investigate and discipline. And 8. File false reports. This claim fails for 2 reasons. First, the facts pled in the complaint do not state a constitutional violation. Thus, this court need not even address the Monell claim. Second, even if the facts do not state a constitutional violation, or even if the facts do, state a constitutional violation, Wallace has pled no facts supporting the claim. In addition, because the complaint does not state a claim against the officers, the state law claims must also be dismissed. Wallace's Monell claim against LVMPD must be dismissed. Wallace has not pled facts supporting a constitutional violation against the individual officers. To bring a Monell claim, Wallace must first plead facts supporting a constitutional violation. See City of Los Angeles versus Heller, Supreme Court, 1986, which says, if a person has suffered no constitutional injury at the hands of the individual police officer, the fact that the departmental regulations might have authorized the constitutional violation is quite beside the point. The facts pled do not support any of Wallace's alleged constitutional violations. So basically, what Heller says is, well, even if the police department have a policy of you've got to punch them in the nuts every time you do an arrest, and that's unconstitutional. But even if they have that policy, if Floyd hasn't alleged that he was punched in the nuts, that policy is irrelevant because he hasn't alleged he was punched in the nuts. So the existence of that policy has no bearing on this case. So because Floyd has not alleged that the officers violated any policy or has committed a constitutional violation, which would be supported by official policy or custom of the LVMPD, he hasn't alleged such injury, well, then it doesn't matter if there is a policy. But he also hasn't alleged the actual existence of any such policy. He's just made conclusory statements saying, well, yeah, they have a policy, but he hasn't said what the policy is. So he hasn't pled it. But he also hasn't pled the injury from the policy. So he fails on both points. It's almost like there's a reason lawyers go to law school for 3 years. The unlawful detention false arrest claim, first cause of action. Wallace argues the officers lacked reasonable suspicion to detain him and lacked probable cause to arrest him. According to Wallace, he went to an LVMPD substation wearing a mask and stood just outside a gate marked police personnel only and began filming inside the restricted area. When an officer questioned Wallace, he ignored the officer and refused to answer his questions. In response, officers detained Wallace where he initially refused to identify himself. Wallace never provided the officers any reason for his suspicious behavior. Because the officers were never provided any valid reason for Wallace filming in a restricted area while concealing his identity with a mask, the officers cited plaintiff for attempted trespassing. And those are all facts taken from Floyd's complaint. But taken as true, there was reasonable suspicion because he was suspicious as hell. The Constitution does not guarantee that only the guilty will be arrested. That's Olson versus Henderson from, that's going to be, I'm guessing, a Nevada case from 2014, which itself cites Baker versus McCullen from the U.S. Supreme Court in 1979. So what does that mean? Let's analyze that statement before we read on. The Constitution does not guarantee that only the guilty will be arrested. What does that mean? That means that even if you're arrested and the charges are dropped, or you're found not guilty at trial, it doesn't mean that there was a constitutional violation, because the Constitution doesn't guarantee that if you're arrested, you'll be convicted. Otherwise, violation. So any arrest is privileged if it is made pursuant to probable cause, not any arrest that is not beyond reasonable doubt is a violation. No, it's if you were violated without probable cause, there's a violation. To determine whether an officer has probable cause at the time of an arrest, a court considers whether at that moment the facts and circumstances within the officer's knowledge were sufficient to warrant a prudent man in believing that the petitioner had committed or was committing an offense. That's from Edgerly versus City and County of San Francisco, 9th Circuit 2010, citing Beck versus Ohio, Supreme Court, 1964. And look at that. Here we have city is not abbreviated, county is abbreviated, but with an N, like I guessed. So it was city up above when it was abbreviated. Once again, I hate the blue book. So yeah, it's at that moment when the officers were in the parking lot and then on the street, and Floyd was filming a restricted area, masked up, concealing his identity, refusing to identify himself when asked. At that moment, that was suspicious as hell. That was reasonable suspicion. It was more than reasonable suspicion. It was probable cause. Thus, his claims fail. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officers had probable cause to arrest for any criminal offense, regardless of their stated reason for the arrest. That's Devin Peck versus Alford, Supreme Court, 2004. So, regardless of their stated reason, let's go back to DeCastro versus LVMPD. He complains, well, they didn't tell me. They told me I was under arrest for resisting arrest, but how can I be under arrest for resisting arrest? Well, you were also arrested for obstruction, but they don't have to tell you that. It's regardless of their stated reason for the arrest. When the underlying facts claimed to support probable cause are not in dispute, whether those facts constitute probable cause is an issue of law. See Orneas versus United States Supreme Court, 1996. So it's an issue of law. So remember, who decides issues of law? The court, not the jury, not the plaintiff, certainly. They don't decide issues of law. So remember, in both complaints, in Floyd's and Delete Lawz, I was arrested without probable cause. They think that has to be taken as a fact, but it's an issue of law. It's an issue of law. Probable cause, the determination of probable cause is an issue of law. I'll say it again. The determination of probable cause is an issue of law. Same with reasonable suspicion. It's an issue of law. The judge decides. So the judge gets to look at these facts that were alleged and say, taken as true, say, well, yeah, there was probable cause. It was a good arrest. Case dismissed. So if Delete Lawz, despite the previous motion we read, if he actually responds to this, I look forward to him misstating the law and saying, but we said that there was no probable cause. You've got to take that as true. You've got it. To which Craig Anderson can just say, nope. He won't, but yeah, or if Floyd responds, it's just going to be in crayon and oof, it'll be bad. The eventual disposition of the charges is immaterial to a court's probable cause determination, as a conviction requires a higher burden of proof than is required to show probable cause. CEG, Peschel versus City of Missoula, District of Montana, 2009, which cites Illinois versus Gates from the Supreme Court in 1983. The probable cause analysis is the same whether under federal law or Nevada state law. See Marshall versus City of Carson, Nevada Supreme Court, 1970. So, like I've said many times, many times. Well, first off, if there's a conviction, that just proves there was more than probable cause. It was the higher standard mentioned here. Conviction requires a higher burden of proof. Reasonable doubt standard. So that means that there's definitely probable cause. So case dismissed. Well, civil case dismissed. But you don't need that. So even if you're not convicted, so if Floyd won at trial and was not convicted, or in this case, charges dropped, so no conviction, that doesn't mean there wasn't probable cause. It means either the prosecutor decided that there was probable cause. Well, they wouldn't have really decided that. It was the police officer, but I'm sure the prosecutor agrees. But they decided, I don't know this rises to the level required for a conviction. There may be reasonable doubts, so I'm dismissing it. Or it's, well, I think I can get a conviction, but it's not going to be worth the time, so I'm dismissing it. But that doesn't mean there isn't probable cause. The law is clear. A police officer is not liable for a false arrest so long as the facts and circumstances known to the officer or arresting person at the moment of arrest would warrant a prudent person's belief a crime had been committed by the person arrested. The requirement of the presence of probable cause is not one of absolute certainty, but rather one of a fair probability that the arrested person has committed the crime for which he is charged. That's U.S. versus Potter, Ninth Circuit, 1990. Probable cause demands factual specificity and must be judged according to an objective standard. That's U.S. versus Struckman, Ninth Circuit, 2010. In Nevada, a finding of probable cause may be based on only slight evidence. I'm going to say that again. In Nevada, a finding of probable cause may be based on only slight evidence. See Sheriff Clark County versus Badillo, Nevada Supreme Court, 1979, which found probable cause despite conflicting witness testimony when one of the witnesses identified the respondent as one of the perpetrators. When an arrest is made with probable cause, the arresting individual is granted immunity, citing Hutchinson versus Grant, Ninth Circuit, 1986. The subjective intentions and motivations of individual officers play no role in the probable cause analysis. See Arkansas versus Sullivan, Supreme Court, 2001, and U.S. versus Magoyan Lopez, Ninth Circuit, 2016, where probable cause standard is objective. It does not turn either on the subjective thought processes of the officer or whether the officer is truthful about the reason for the stop. Here, the officers clearly had reasonable suspicion to detain and investigate Wallace's behavior. The material facts surrounding Wallace's detention and arrest are: 1. Wallace was loitering near an employee-only gate at the LVMPD substation. 2. Wallace was acting suspicious by wearing a black mask over his face and getting as close to the restricted area as possible while filming. And 3. The officers attempted to ascertain the purpose of Wallace's suspicious and threatening behavior, and he refused to explain. These facts, viewed as a whole, confirm Wallace was not sensitive to the seriousness of the circumstances he created. Even if Wallace did not intend to enter the restricted area, it is admitted he was filming in an area where LVMPD's security and safety were vital. In Dave versus Laird, the Southern District of Texas examined a similar case where a plaintiff was filmed in a public breezeway behind a police building and a dead-end alley where officers parked their police vehicles. That's Dave versus Laird, Southern District of Texas, 2021. When officers confronted the plaintiff, like Wallace, he responded in a hostile manner. The district court dismissed plaintiff's false arrest claim, concluding that reasonable suspicion existed to detain because plaintiff filming where police officers parked their vehicles would likely cause suspicion, and a reasonable person filming in this area would know that their actions might cause legitimate worry or even fear on the part of police officers who depend on the security of their building and integrity of their vehicles for their safety. And see also Turner versus Lieutenant Driver, Fifth Circuit, where it was reasonable to detain an individual filming police station from a public sidewalk, as police are able to take into account the location of the suspicious conduct and the degree of the potential danger being investigated. In addition, the officers had a probable cause to cite Wallace. The officers cited Wallace for attempted trespass. Nevada Revised Statute, Section 207.200, sub 1, which makes it a misdemeanor for any person under circumstances not amounting to burglary to go upon the land or into any building of another with intent to vex or annoy the owner or occupant thereof, or to commit any unlawful act. Wallace admits he approached a closed, I assume that's supposed to say closed off, he's missing an F, but closed off area prohibited to the public and began filming the prohibited area. When detained by the officers, Wallace refused to explain his suspicious behavior. Therefore, the officers only knew Wallace was skulking around a prohibited area, wearing a mask, and filming sensitive information prior to being confronted by the plainclothed officer. I like the word there, skulking. Because Wallace refused to provide an explanation for his unusual behavior, the officers reasonably concluded that a fair probability existed that Wallace was. Oh, come on, Anderson. Wallace was there to, spelled as the possessive, Their, to vex or annoy the owner or occupant, or commit an unlawful act. See Nevada Revised Statute Section 201.200 sub 1. Finally, as stated above, probable cause can exist for a crime not charged. See Devon Peck from Supreme Court, U.S. Supreme Court says probable cause can exist for a crime not charged. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officers had probable cause to arrest for any criminal offense, regardless of their stated reason for the arrest. Under Nevada Revised Statute Section 197.190, it is obstruction under Nevada law to impede or prolong an investigation. Not charged, but there was reasonable suspicion for obstruction, because by him not identifying, he was impeding or prolonging their investigation. See Tsao versus Desert Palace, Inc., 9th Circuit, 2012. Nevada district courts have held that an individual is obstructing when the individual is given several opportunities to comply with defendant's orders, but fails to do so. That's Kelly versus Las Vegas Metropolitan Police Department, Nevada courts in 2014. Wallace admits he initially impeded the officer's investigation by failing to identify himself and that this delayed them. So reasonable suspicion, even though not charged, existed for obstruction. And remember above, it's even if you're arrested and they don't state why you're arrested, they don't state what they had reasonable suspicion for. So even though they arrested him and said, "We are arresting you for attempted trespassing," reasonable suspicion existed for the unstated crime of obstruction. And that's enough. That's enough for them to win. Next, the unreasonable search and seizure of property, first cause of action. Wallace also alleges an unreasonable search and seizure of property. The complaint alleges Wallace was searched and transported to Clark County Jail. The complaint does not allege any of Wallace's property was searched. Under Terry versus Ohio, an officer may pat down a detained person who they reasonably believe may be armed and dangerous. And that's, of course, from the Supreme Court in 1968. This brief search is to allow officers to conduct investigations without fear of violence. That's Adams versus Williams, Supreme Court, 1972. Further, when a suspect is arrested, a police officer may conduct a warrantless search incident to an arrest of both the arrested person and the area within his control. And that's Chimel versus California, Supreme Court 1969, which was abrogated on other grounds by Arizona versus Grant by the Supreme Court in 2009. So that's remember in previous videos how I've mentioned the shepherdizing and the red flags and yellow flags. So Chimel versus California probably has a yellow flag saying, hey, that this is contradicted by newer case law, but it's abrogated on other grounds. So it's still good for the proposition under this set of facts, but it's maybe not good to cite for other reasons. So it might be that Chimel versus California says, well, yeah, you can conduct a search incident to arrest on the person you're arresting and the area in their control. But then the Supreme Court later said, well, Chimel is bad law because the initial stop was bad. So, or well, they wouldn't say it about Chimel, but in Arizona versus Grant, they'll say, well, yeah, Grant was stopped and the stop was similar to Chimel, but it was a bad stop. So we're overturning it and saying that was a bad stop. So, but that doesn't say anything about the search incident to arrest. And that's just me, hypotheticals. So, but that's basically what it means, abrogated on other grounds. Excessive force, first cause of action. Wallace's first cause of action also alleges excessive force. The only force referenced by the complaint, beyond the lawful search of Wallace's person, is that an officer drew his gun while approaching Wallace. Courts approach excessive force claims in 3 stages. See Espinosa versus City and County of San Francisco, 9th Circuit 2010, and Graham versus Connor, Supreme Court 1989. First, the court assesses the severity of the intrusion on the individual's Fourth Amendment rights by evaluating the type and amount of force inflicted. Then, the court evaluates the government interests by assessing the severity of the crime, whether the suspect posed an immediate threat to the officer or public safety, and whether the suspect was resisting or attempting to escape. That's from Graham. Here, Wallace alleges an officer approached him with a gun drawn. Wallace does not allege the officer threatened him with the firearm or pointed it at his head. It is not unreasonable for an officer to pull his firearm when approaching a suspicious individual who is wearing a mask over his face and has not been frisked for weapons. According to the Ninth Circuit, the drawing of a weapon becomes unreasonable when the police officer terrorizes a civilian by brandishing a cocked gun in front of that civilian's face while investigating a minor crime. That's Robinson versus Solana City, 9th Circuit, 2002. By simply approaching Wallace with his gun drawn, the officer did not use excessive force. 14th Amendment Equal Protection Claim, second cause of action. Wallace alleges the officers violated his 14th Amendment equal protection rights because they arrested him due to the color of his skin, his position as a member of the press, and due to his political affiliation. To state a Section 1963, that should be 1983, claim for violation of the Equal Protection Clause of the 14th Amendment, a plaintiff must allege that the violation was committed with an intent or purpose to discriminate based on plaintiff's membership in a protected class. And that's Lee versus City of Los Angeles, 9th Circuit, 2001. To prevail on a selective enforcement claim, The plaintiff must show that the enforcement had a discriminatory effect and the police were motivated for a discriminatory purpose. That's Lacey versus Maricopa County, Ninth Circuit 2020. Where the challenged governmental policy is facially neutral, proof of its disproportionate impact on an identifiable group can satisfy the intent requirement only if it tends to show that some invidious or discriminatory purpose underlies the policy. If the action does not involve a suspect classification, a plaintiff may establish an equal protection claim showing that similarly situated individuals were intentionally treated differently without a rational relationship to a legitimate state purpose. That's Village of Willowbrook versus Olek, Supreme Court 2000. I'm recognizing a whole bunch of these citations because they're in the DeCastro versus LVMPD motion to dismiss. To state an equal protection claim under this theory, a plaintiff must allege that 1. The plaintiff is a member of an identifiable class. 2. The plaintiff was intentionally treated differently from others similarly situated. And 3. There is no rational basis for the difference in treatment. Here, Wallace alleges officers intentionally discriminated against him based on the color of his skin, his position as a member of the press, and due to his political affiliation and viewpoints, even though his political affiliation and viewpoints were never expressed. First, Wallace's complaint admits he refused to provide any information to the officers beyond his identity. Thus, the officers could not have discriminated against him as a member of the press or due to his political views, as he never made these facts known. See Iqbal, threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. So, stating, I was discriminated because I'm a member of the press. I was discriminated against because of my political viewpoints. Those are threadbare recitals, conclusory statements, not factual allegations. Further, the press is not a protected class. How many times do we have to say that? The press is not a protected class. We might need to do merch saying the press is not a protected class. Second, Wallace's racial profiling claim cannot meet the final two prongs established in the Willowbrook case. Because, he is African American, so he is part of a protected class based on race. So that actually does meet the first element, but he's got to show that's why he was arrested. But I mean, Delete Lawz filing a identical lawsuit, and Delete Lawz being as white as I am, despite his Hispanic name, shows, hey, they arrest people brandishing cameras and where they're not supposed to, and interfering and harassing police. They arrest people of all races. So this actually goes against his claim. The complaint does not allege Wallace was intentionally treated differently from others that are similarly situated to him, and there was no rational basis for the difference in treatment. Specifically, Wallace has failed to provide facts that non-African American individuals who were filming the protected areas of police stations were not detained or arrested. And furthermore, he was wearing a black ski mask. When they initiated the contact, who's to say they even knew his race? And he had a hoodie. He had a mask. So as far as we know, I don't know if he had gloves or not. I don't think so, but that means his hands were really what were visible. So did they see his race? I don't know. First Amendment claim, third cause of action. Wallace claims the officers violated his First Amendment rights by retaliating against him for his speech. including his verbal protests and criticisms of the defendant's actions in investigating, detaining, and arresting plaintiff without any basis. Because Wallace admits he never verbally protested or criticized the officers, his claim is really that they arrested him for filming police activity. The Ninth Circuit has held that there is a First Amendment right to film the police. See Fordyce versus City of Seattle, Ninth Circuit, 1995. Askins versus U.S. Department of Homeland Security, Ninth Circuit, 2018, which says there is a right to record law enforcement officers engaged in the exercise of their official duties in public places. The right to film may be subject to reasonable time, place, and manner restrictions. Gilk versus Cuniff, First Circuit, 2011. The Ninth Circuit has held that reasonable content neutral time, place, or manner restrictions, on the other hand, are subject to an intermediate level of scrutiny. Jacobson versus U.S. Department of Homeland Security, Ninth Circuit. Restrictions in a non-public forum must only be reasonable in light of the purpose served by the forum and viewpoint neutral. Here, so that's the intermediate scrutiny. So reasonable in light of the purpose served by the forum. So the purpose would be keeping the police safe, keeping the police compound, which is, police station, secure parking area, secure, and viewpoint neutral. So they can't say you can do the exact same thing Floyd did, but if it's pro-police, so if you approach the secure police parking lot and you're masked and you don't respond and you are acting suspicious as hell, but you're pro-police, it's allowed. But if you're anti-police, it's not allowed. No, it's got to be viewpoint neutral. So it's got to be either allowed for both or disallowed for both. Here, Wallace was not arrested for filming, but rather for attempted trespass. Assuming Wallace's arrest was in retaliation for his filming, the claim would still fail. Wallace admits he was attempting to film inside a non-public, gate-guarded area that was off-limits to the public. It is reasonable for security reasons to restrict individuals from filming officers leaving and entering police stations. Thus, Wallace has not pled facts sufficient for a First Amendment violation. Next, 42 U.S.C. Section 1981 claim, the fifth cause of action. Wallace's fifth cause of action alleges the officers discriminated against him because of his race and political affiliations. 42 U.S.C. Section 1981 prohibits discrimination in the making and enforcement of contracts by reason of race, national origin, or ancestry. In the making and enforcement of contracts with the government. Well, what contract? What contract was Floyd making? What contract? There wasn't one. It prohibits racial discrimination through state or private action and requires a showing of intentional discrimination on account of race. And that's Evans versus McKay, Ninth Circuit, 1989. A claim of false arrest cannot typically provide a basis for a Section 1981 claim. See Brew versus City of Emeryville, Northern District of California, 2001, which cites Morgan versus the District of Columbia, District of DC, 1982, which was affirmed by the DC Circuit in 1983. To survive a motion to dismiss for failure to state a claim, a plaintiff alleging a Section 1981 claim must allege overt acts coupled with direct evidence that the defendant's conduct was motivated by animus against the protected class. See Evans versus McKay, Ninth Circuit, 1989. The mere knowledge of plaintiff's ethnicity coupled with a conclusory assertion of discriminatory animus for defendant's action, does not create a plausible inference necessary to survive a 12b6 motion. Jahan Zeb Mir versus State Farm Mutual Auto Insurance, uh, Central District of California, 2019. Here, Wallace has sufficiently alleged he is a member of a protected class based upon his race. However, he has pled no facts suggesting he was denied the right to contract for services. Therefore, this claim is untenable as a matter of law. Even if Wallace has pled a viable 42 U.S.C. Section 1983 claim against the individual officers, he has not pled sufficient facts to support a Monell claim. Assuming arguendo, a great word, arguendo, for the sake of argument, Wallace has pled a constitutional violation, he must then connect the alleged violation of an LVMPD custom, policy, or practice by pleading specific facts. To properly plead a Monell claim against LVMPD, Wallace needed to 1. Identify the challenged policy or custom. 2. Explain how the policy or custom is deficient. 3. Explain how the policy or custom caused the plaintiff harm. And 4. Reflect how the policy or custom amounted to deliberate indifference, i.e., show how the deficiency involved was obvious and the constitutional injury was likely to occur. That citing Harvey. Here, Wallace has not identified a specific policy or practice. Instead, he pleads conclusory allegations of the existence of unconstitutional customs, policies, or practices relating to LVMPD's Fourth Amendment policies and procedures. However, there is no identification of a policy that, when enforced, caused the alleged constitutional violation. See Baxter. Wallace instead generally pleads LVMPD has policies that allow and ratify officers to commit a myriad of constitutional violations, but with no specifics. Wallace's conclusory assertions are belied by the fact he fails to identify a single other incident or event where similar supposed constitutional violations occurred. Once again, I think that's why Delete Lawz conspired with Floyd to get Floyd arrested so that Delete Lawz, in his case, could say, see, look, you arrest journalists, I'm a journalist, so Monell works. See, this proves the policy. Wallace fails to plead facts demonstrating any of the following. Did I get lost? Either way. Wallace fails to plead facts demonstrating any of the following. 1. An express policy that, when enforced, causes a constitutional deprivation. 2. A widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Or 3. Constitutional injury caused by a person with final policy-making authority. Therefore, plaintiff has failed to adequately plead or plead a specific policy or practice, and plaintiff's Monell claim must be dismissed pursuant to 12b6 accordingly. Second, Wallace's allegations are based solely on his experience, and based on this fact alone, the Monell claim must be dismissed. See Tuttle from the Supreme Court. The state law claims against LVMPD must be dismissed. Wallace also includes LVMPD in his state law claims for assault, battery, false arrest, and imprisonment, invasion of privacy, and negligence. As to assault and battery, Wallace's state law assault and battery claim is the same as his 42 U.S.C. Section 1983 excessive force claim. He alleges excessive force was used by pointing the gun at him and then taking him into custody. First, any touching of Wallace was privileged as it was pursuant to a valid arrest, and he does not allege any facts suggesting unnecessary force was used to search him or handcuff him. Second, the assault claim involving the pointing of the gun fails for the same reason Wallace's Fourth Amendment excessive force claim fails. And that's citing Ramirez versus City of Reno, District of Nevada, 1996, which says the standard for common law assault and battery by police officers mirrors the federal civil rights law standard. And it's worth pointing out, remember, from Delete Lawz motion to dismiss and opposition, for Nevada state law claims, police do not have qualified immunity, but they do for the federal claims. So they don't have qualified immunity for the state law claims, which assault and battery are state law claims. But they do have qualified privilege. So any touching of Wallace was privileged. False arrest and false imprisonment. The false arrest and imprisonment claim is identical to Wallace's Fourth Amendment unreasonable search and seizure claim. The probable cause analysis is the same whether under federal law or Nevada state law. See Marshall and Badillo, which says probable cause only requires slight evidence. In addition, the officers are protected by discretionary immunity under Nevada Revised Statute Section 41.032. See Gonzalez versus Las Vegas Metropolitan Police Department, Nevada Supreme Court, 2013, which held that an officer's decision to arrest based on a matched description and a facially valid warrant was entitled to discretionary immunity. I believe that citation was made in the DeCastro versus LVMPD 2. In Gonzalez, the court found LVMPD's decision to arrest or detain Gonzalez based on a warrant was part of a policy consideration that required analysis of multiple social, economic, efficiency, and planning concerns, including public safety. And that's Gonzalez, citing Martinez versus Marischak. See also Ortega versus Reyna from Nevada, which concludes that no civil liability attached to a state trooper's decision to arrest a driver for allegedly refusing to sign a traffic ticket because the decision to do so was a discretionary decision requiring personal deliberation and judgment, and thus was entitled to immunity under NRS 41.032 sub 2, Cody versus Washoe, Nevada, 1992, which says the decision of whether to make an arrest is largely discretionary. Invasion of privacy. Nevada's common law recognizes the tort of invasion of privacy for unreasonable intrusion upon the seclusion of another. The purpose of the tort is to provide redress for intrusion into a person's reasonable expectation of privacy. That's Clark County School District versus Las Vegas Review-Journal from Nevada Supreme Court, 2018. The tort of invasion of privacy embraces 4 different actions. A, unreasonable intrusion upon the seclusion of another. Or B, appropriation of the other's name or likeness. Or C, unreasonable publicity given the other's private life. Or D, publicity that unreasonably places the other in a false light before the public. That's from the Restatement Second of Torts, Section 652A, 1977, and PETA versus Bobby Barosini, Nevada Supreme Court, 1995. Wallace alleges the officers committed this tort by searching him. However, as set forth above, the search was lawful, as it was a basic search pursuant to a lawful arrest. Finally, negligence. Wallace alleges the officers conducted a negligent investigation that led to his arrest. Therefore, if the arrest was lawful, this claim fails. In addition, the officers are immune pursuant to Nevada Revised Statute Section 41.032. See Pittman versus Lower Court Counseling, Nevada Courts, 1994, which says The nature of an investigation is inherently discretionary. And Foster versus Washoe County, Nevada Courts, 1998. Conclusion. Based upon the above, defendant LVMPD requests it be dismissed from this lawsuit, dated this 17th day of July 2023, Markey Auerbach, signed Craig R. Anderson. And certificate of service, it was mailed to Floyd in College Station, Texas, and I have doubts that Floyd is actually receiving mail there or monitoring the mail, so we'll see if this is responded to. So with that, that's all I'm covering today. Like I said, I'm trying to get some of the backlog done before my vacation. So spoilers, there are motions to cover in Scofield versus Giard. There are still motions I need to cover in DeCastro versus LVMPD. And even though I haven't covered the case, there's an absolute banger in DeCastro versus Wagner. So I might just have to make an exception and do that one because, oh my, the judge tore him a new one. But with that, a reminder, support Professor Scofield. It's a good cause, keeps us entertained. And other than that, like, share, subscribe, and I will see you soon. Thanks for joining me.